This is one of those cases that makes you stop and ask, how far is too far when it comes to loyalty, especially inside a family? Today's courtroom drama isn't just about drugs, prison, or sentencing. It's about a father who allegedly crossed a line so severe that even the judge couldn't hold back his outrage. We're talking about a man accused of pulling his own daughter, just 22 years old, a new mother with an infant at home, into a high-risk drug operation inside a correctional facility. Now think about that for a second. This isn't just a bad decision. This is a life-altering move with consequences that ripple across generations. A young woman with no prior criminal history suddenly facing mandatory prison time, all because of a choice that may not have even been fully her own. As we go through this case, pay close attention to the courtroom dynamics, the judge's tone, the defendant's responses, and the prosecution's arguments. Because what unfolds here isn't just about guilt or innocence, it's about responsibility, manipulation, and the harsh reality of the justice system. And here's the big question I want you to keep in mind as we dive in. Was this a desperate act or a calculated betrayal?
Because just absolutely shame on you for putting your daughter through this and having her face an indictment with mandatory prison. If she gets convicted, I didn't have a choice but to send her to prison. She has no prior record. Why would you drag your daughter into that who has your grandchild at home? What, 4 months old, 5 months old? Why would you do that? But to talk your own daughter into doing something like this is just absolutely disgraceful.
25 CR 42362, the state of Ohio versus Kenneth Carney. Mr. Carney is before the court. Mr. Carney, have you retained new counsel?
I didn't get a chance to because I'm gonna wait till after the holidays. I think he had a caseload over. He had too many cases. So the ones that I never try to call, because I got back to Lucasville December 15th. By the time I got to use the phone and call lawyers, they told me I'll call after the holidays.
Mr. Carney, this is unacceptable. I'm not going to continue to drag this case out. This case is approaching a year old already.
You're saying that's unapproachable? What's unapproachable about it? I can't make a lawyer come to work. They was busy. It was the holidays.
Well, I'm going to appoint you new counsel today.
And then you give me a lawyer last time. He ain't even do nothing. I asked, he ain't come and see me. Still ain't got no discovery or nothing. James Moss ain't giving no discovery. I don't even know what's going on. Never came to see me or nothing. So how's it my fault?
What you're seeing here is a classic courtroom tension point when a defendant claims they haven't had proper legal representation. Mr. Carney is essentially arguing that his previous attorney failed to provide discovery, which is critical evidence needed to build a defense. Now, legally speaking, every defendant has the right to effective counsel, and if that right is compromised, it can become grounds for appeal later on. But notice the judge's reaction. He's clearly frustrated. This case has already been delayed multiple times, and courts don't take kindly to what they perceive as stalling tactics. So instead of entertaining more delays, the judge makes a decisive move, appoint new counsel and push the case forward. Now here's something to think about. Is Mr. Carney genuinely being denied proper representation, or is this an attempt to delay the inevitable? Because in the courtroom, timing is everything, and patience runs out fast.
Well, I just said I was going to appoint you counsel.
I'm
going to set this for trial here in the next month or so. This case, like I said, is almost a year old. We've had.
Yeah, but
I'm not, sir. This is not time to argue with me. I'm telling you what I'm going to do. I'm going to appoint new counsel. Now, if in the meantime, between now and 2 weeks from now, that you hire a new attorney, that's fine. But I need to keep this case moving. This case is almost a year old, and I've had it set for trial twice already.
Yeah.
This will be the third trial setting. I'm not going to continue to play this game. So here's where we are.
No
Mr. Lawson is going to hand you a form. It's an affidavit of indigency saying you can't afford to hire an attorney. If you come up with the funds and you hire an attorney in the meantime, that's fine. That's great. Yeah. But in the meantime, I'm going to appoint someone to represent you. Are you still at Lucasville?
Yeah.
Okay. All right, so I'm going to go ahead and accept this today, and then again, like I said, if you end up retaining someone, we're after the holidays now. If you end up retaining someone, they can reach out to me and substitute in as counsel of record. That's not a problem, but I just want to keep the case moving. Okay, so this verdict form is signed by all 12 members of the jury. As to the additional finding to count one, we, the jury, find the amount of methamphetamine involved in the offense was equal to or in excess of 5 times the bulk amount.
but less than the 50 times bulk amount. This additional finding is also signed by all 12 members of the jury. As to count 2, we, the jury, being duly impaneled, sworn, or affirmed, find the defendant, Kenneth Carney, guilty of illegal conveyance of drugs of abuse under the grounds of a specified government facility.
And just like that, the jury delivers its verdict, guilty. But let's break down what makes this moment so significant. The charges aren't minor. They involve trafficking a substantial amount of methamphetamine and illegally bringing drugs into a correctional facility. That's already serious. But what makes this case stand out is the method, using his own daughter as the courier. The jury didn't just find him guilty, they also confirmed the drug quantity exceeded 5 times the bulk amount, which directly impacts sentencing severity. In simple terms, that means harsher penalties are now almost guaranteed. Now here's the bigger picture. Juries are instructed to weigh evidence carefully and avoid emotional bias. So for them to come back with a unanimous decision like this, it suggests the prosecution presented a strong, convincing case. But let me ask you, do you think the jury was influenced more by the evidence or by the emotional weight of involving his daughter?
He stands charged in the indictment. This verdict form is also signed by all 12 members of the jury. Does the state want the jury polled?
No, Your Honor, thank you.
Does the defense want the jury polled?
No, Your Honor.
Before I pronounce sentence, anything from the state?
Your Honor, the court heard the testimony in this case. The court's aware of the facts. The defendant has an extensive history of drug trafficking dating back to at least 2006. This was 51 grams of methamphetamine that he got his daughter with no criminal history to bring in to the Warren Correctional Institution for him, and the court heard his testimony. So we would ask you to consider all of that and impose a sentence of at least 6 years.
Mr. Brenner, anything on behalf of the defendant?
Thank you, Your Honor. I've gotten to know Mr. Carney pretty well over the last couple months I've been on this case. I think he's a polite man. I think he's an affable man. I think that he's in a situation where I know this court's well aware of the circumstances surrounding, the Department of Rehabilitation and Corrections. Obviously, we think he made some bad choices here, right? I think that he sought to, alleviate his circumstances as it was. But I do know that he has, I know the court's aware, he's been transferred to Lucasville. It's a much higher security level. I know that is not enjoyable for him. I think he's already faced some consequences. I would ask this court to issue an appropriate sentence on the lower end, as I think it's notable. Obviously, none of the contraband was ever actually possessed by Mr. Carney.
Mr. Carney, is there anything you'd like to say before I sentence you?
I just apologize. There's nothing I can say. Apologize to the court. I have nothing to do with it. I still remain innocent, but
I'm sorry, I can't hear you.
I still remain, innocent to where I didn't do it, but there's nothing I can do about it. I can just apologize to the court. That's all.
This is the moment right before everything changes, the sentencing phase. And if you've watched enough courtroom cases, you know this is where things get real. The defense tries to humanize Mr. Carney, describing him as polite and someone who's already faced consequences. Meanwhile, the prosecution paints a very different picture, highlighting his long criminal history and the calculated nature of the crime. And then we hear from Mr. Carney himself. He apologizes, but at the same time, he maintains his innocence. That's a risky move. Judges often look for genuine accountability during sentencing. And when a defendant says, "I'm sorry, but also I didn't do it," it can come across as inconsistent. So here's a question for you. Does an apology still carry weight if the person refuses to fully accept responsibility? Because in just a few moments, the judge is about to respond, and it's going to be intense.
The court has considered the statements made here today, the purposes and principles of sentencing, the relevant seriousness and recidivism factors. There are 2 offenses here. The court does find that they are offenses of dissimilar import and do not merge for the purposes of sentencing. Anything on that?
No, the state would agree.
Your Honor, I would ask for them to merge, but I do believe that under Ohio law that they would not automatically merge.
All right, on count 1, then, the court will order you to serve a minimum term before I get to that, Mr. Carney, first off, shame on you. Just absolutely shame on you for dragging your young daughter, who you profess to love, into this. I quite frankly agree with the jury's verdict. I don't often do this. This is probably the second time in 10 years that I've actually sentenced a defendant in front of a jury, and I'm doing it for a reason. Because just absolutely shame on you for putting your daughter through this and having her face an indictment with mandatory prison. Luckily for you, I think that the state, and I think we're going to do it on Thursday, her trial was set for Thursday, as you probably know. If she gets convicted, I didn't have a choice but to send her to prison. She has no prior record. Why would you drag your daughter into that who has your grandchild at home? What, 4 months old, 5 months old? Why would you do
This right here is one of the most powerful moments in the entire case. Judges are typically composed, measured, and strictly focused on the law, but every now and then, a case hits a nerve, and you can clearly see that happening here. The judge isn't just handing down punishment, he's making a statement. He calls out the defendant's actions as shameful, emphasizing the moral failure of involving his own daughter, especially one with no prior record and a young child at home. This goes beyond legal consequences. It's about accountability on a human level. The judge even points out that this is only the second time in 10 years he's chosen to sentence someone in front of a jury. That tells you just how strongly he feels about this case. So let me ask you, should judges express this level of emotion in court, or should they remain completely neutral no matter the circumstances?
that? And that's a rhetorical question, Mr. Carney, because quite frankly, I'm not looking for a response at this, but I'm just scolding you because I think it's shameful for a parent to drag, and we see these cases all the time where people, they talk these young women, but to talk your own daughter into doing something like this is just absolutely disgraceful in my opinion. Your record dates back to 2001, your criminal record. So you have a criminal history of over 25 years. This is your third conviction for aggravated trafficking. 3. You're not learning anything. So the court is going to order you to serve a minimum prison sentence of 5 years, a maximum prison sentence of 7.5 years. That has to do with Reagan Tokes, as you probably are aware. And on count 2, the court's going to order you to serve 36 months. That to be served concurrent with count 1, but consecutive sentence to your current sentence. So I'm adding on 5 to 7.5 years to your current sentence. The court does find that a consecutive sentence is necessary to punish you and to protect the public from you. It is not disproportionate to the conduct or the danger that you pose to society, and this offense was committed while you were already incarcerated in the Department of Corrections. You have 0 days jail time credit. You are subject to a mandatory period of post-release control on this, as you probably already are on your other one, which means that when you are released, the Adult Parole Authority will supervise you for up to 3 years, but not less than 18 months. You do have a right to appeal the jury's verdict and this court's sentence to the 12th District Court of Appeals. If you want to appeal, you must file your notice of appeal within 30 days of today's date. You can't afford to pay for the transcript or anything necessary for your appeal. That can all be provided to you at no cost if you cannot afford an attorney.
Now we transition into something equally important, the aftermath. Mr. Carney is already talking about filing an appeal, which is his legal right. Appeals don't retry the case. Instead, they focus on whether any legal errors occurred during the trial. That could include issues like ineffective counsel, improper evidence handling, or procedural mistakes. But here's where things take a dramatic turn. We're not done with this story yet, because now the courtroom shifts focus to his daughter. And this is where everything comes full circle. Remember, she had no prior criminal history. She's young, a new mother, and now she's standing in court facing serious felony charges. But unlike her father, she chooses a different path. She pleads guilty. So here's the big question. Is this a sign of accountability, or was she pressured into taking the fall?
Attorney, I will appoint one for you at no cost. Ms. Stickles.
Nothing further, thank you, Your Honor.
Mr. Brenner.
Not this time.
All right, that's all. Thank you. All right, ladies and gentlemen, at this time, we are obviously finished, and I oftentimes don't ever do that. I've done it one other time that I can think of. I will explain that to you in the back.
How long it take for the appeal to come in?
Well, I mean, so I'm gonna file it. It'll, like we talked about, it'll probably take a couple weeks to a month with the transcript ready. And then from there, your appellate counsel will have, 4 to 6 weeks to file their brief. Okay? Oh, that's for what? I'll file that.
Are you able to take us off the record?
Case number 25CR42361, the State of Ohio versus Kalia Carney. Ms. Carney is before the court with her counsel, Mr. Staten. Ms. Nicholson, on behalf of the State of Ohio. Ms. Nicholson.
Your Honor, standing, the defendant will be entering a guilty plea to the amended counts 1 and 2, which have both been reduced to felonies of the third degree, aggravated trafficking and aggravated possession, as well as count 3, illegal conveyance. Count 4 has been dismissed. There is no agreement on sentencing. However, the state has indicated to Mr. Staten that it intends to defer to the court.
Staten, is that accurate?
It is, Your Honor.
All right, Ms. Carney, they're telling me you're going to change your plea to guilty to 3 counts, 2 amended counts and 1 additional count from the indictment. Before we get to your change of plea, I am required to go over some things with you, okay?
Okay.
How old are you?
I'm 22.
How far did you go in school?
I went into high school.
So you can read and write?
Yes.
Did you graduate?
Yes.
Okay.
I got my high school diploma.
Okay. Are you a citizen of the United States?
Yes.
Has anyone promised you how the court would sentence you in this matter?
No.
Has anyone threatened you in any way to get you to plead guilty
No.
against your will?
No.
Are you satisfied with the representation you've received from Mr. Staten?
Yes.
Are you currently under the influence of any drugs or alcohol?
No, sir.
Do you take medication that interferes with your ability to understand what's going on today?
No.
I have in front of me a document called a change of plea. On the second page, on the line marked defendant, there is a signature. Did you sign this?
Yes.
Did you read this, go over it with your attorney before you signed it?
Yes.
And you feel comfortable that you understand what it says?
Yes.
All right. This document says running a plea of guilty to 1 count of aggravated trafficking in drugs as a felony of the third degree. That carries a maximum penalty of 36 months in prison and a maximum fine of $10,000. $5,000 of that is a mandatory fine. The second count is one of aggravated possession of drugs, a felony of the third degree. That also carries a maximum penalty of 36 months in prison and a maximum fine of $10,000. And again, $5,000 of that is also a mandatory fine. And the third count is one of illegal conveyance of drugs into the grounds of a specified government facility, a felony of the third degree. That carries a maximum penalty of 36 months in prison and a maximum fine of $10,000. None of these carry mandatory prison sentences. Do you understand the maximum penalties and maximum and mandatory penalties?
Yes, Your Honor.
All right. Now, you're also subject to a discretionary period of post-release control, which means that if you are sent to prison, when you are released, the adult parole authority may decide to supervise you for up to 2 years.
Yes.
If you violate that supervision, the adult parole authority can return you to prison for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer, and that time would run consecutive to any additional prison time that you get sentenced to. Do you understand that?
Yes, sir. Yes, Your Honor.
Now, you are presumed innocent of these charges. You cannot be sentenced or punished unless you plead guilty or you're found guilty following a trial. Do you understand that?
Yes.
Ms. Nicholson.
If this case would have proceeded to trial, the state would have proven beyond a reasonable doubt that on or about July 28th, 2024, at Warren Correctional Institution in Turtle Creek Township, Warren County, Ohio, the defendant transported in a concealed a flaming hot Cheetos bag containing over a bulk amount of methamphetamine. He entered the institution and concealed that in a trash can for retrieval. She did that in conjunction with her father and an associate of her father.
Mr. Staten, anything on those facts?
Nothing, Your Honor. Thank you.
Ms. Carney, did you hear the statement that was read?
Yes.
Do you admit and acknowledge that what she said is true?
Yes.
And again, you understand all the rights you're giving up by entering a plea of guilty,
Yes.
the rights we went over.
Yes.
What is your plea?
Guilty.
All right, the court's going to make a finding then that you've made a knowing, intelligent, and voluntary waiver of your constitutional rights, and the court will accept your plea of guilty, and based upon the statement of facts in your plea, the court will make a finding of guilty. Now, Ms. Carney, I'm going to order a pre-sentence investigation. We'll come back in a few weeks, and we'll do sentencing at that time. It'll probably be 6 to 8 weeks before we do sentencing, but you need to go back down to court services this morning?
Yeah. No, not yet.
Okay, you need to test this morning?
Yeah, she told me to come right after court so I could be able to sign it.
This case leaves us with a lot to unpack. On one hand, we have a father with a long criminal history, convicted of orchestrating a drug operation from inside prison, ultimately receiving an additional 5 to 7.5 years on top of his existing sentence. On the other hand, we have his daughter, a first-time offender, who ends up pleading guilty to reduced charges, potentially altering the course of her life forever. Legally, the system worked as designed. Evidence was presented, a jury reached a verdict, and the judge applied sentencing based on both the law and the circumstances. But emotionally and morally, this case hits much deeper. It raises questions about influence, responsibility, and the impact of one person's decisions on an entire family. And maybe the biggest takeaway here is this: choices don't just affect you, they affect everyone connected to you. Now I want to hear from you. Do you think justice was served in this case? Or was the outcome too harsh or not harsh enough? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
All right, yeah, and that's, you need to set up, or you need to schedule your interview for the pre-sentence investigation.
Okay.
All right.